Hello, my name is Ted Kirscher from Landrum Human Resources, and I'd like to welcome you to today's webinar. We're going to talk about healthcare reform, a very confusing and complex issue, and what it means to employers as well as individuals. We have with us today Amy Remington, General Counsel of Landrum. Welcome, Amy.
Thank you, Ted. And
Todd Torgerson, from the President of Combined Insurance Services. Welcome, Todd.
Thanks, Ted. Pleasure to be here.
Great. Let's talk a little bit about our intent on how we're going to cover things today in this discussion point. We're going to first talk about items that are of immediate concern. Then we'll move into 2014 and beyond. And as I mentioned, we're going to be talking both from an individual perspective as well as an employer perspective about the things you need to be concerned about. We do have a disclaimer, of course, that this is information that's designed to inform you about the law, but it certainly is not meant to be used for legal or tax advice. Probably the thing that you have to realize first, and will be sort of a continuing theme through the entire webinar today, is that we have the law. The law was passed in 2010 and affirmed for the most part by the Supreme Court in the summer of 2012. But really, we've got the regulations that are going to implement this law have really just started flowing. We've got 2,000 pages of laws, and probably by a factor of 4 or 5 or more times that many regulations that have yet to be published. In fact, we even during Thanksgiving week, I think we had 3 different regulations that were proposed during Thanksgiving week. So it's important for you to realize that these items are just really coming hot and heavy, and the regulations will be with us and be with us actually probably for the next several years. But let's talk first about the items that require immediate attention, the things that are in place now or will be in effect very shortly. And one of the first of those relates to W-2 reporting. Amy, talk to us about the new rules regarding W-2 reporting.
That really is one of the first items for immediate attention. This applies to employers who issued 250 or more W-2s in the year 2011. For those employers, they need to add the health value or the value of those health benefits to W-2s that are issued in January of 2013. And by health, I mean broadly, health, dental, vision, employee assistance plans, anything like that. The employer can use the COBRA value to calculate that, but it does have to be a line item on the W-2 issued in January of 2013. And it's not a taxable amount. That's one common misconception. It's not a taxable amount. It's just for informational purposes only.
Right. So fortunately, it's going to apply only to those really, in this case, rather large employers that issued 250 or more W-2s. That's all it applies to at this time. I guess the key points, 250 or more and not a tax is really probably the key provisions about that. Okay.
And the other item for most immediate attention is summary of benefits and open enrollment changes.
That's right, Amy. This is going to be a huge deal because if employers don't comply, they really need to pay attention with this. If they don't comply, there's going to be fines involved. And really what this is, it's a government-designed summary of benefits and coverage that is designed to help us better understand our benefits and better compare benefits. Now, the way it works is this. If you're a fully insured group, the insurance company is responsible for producing these forms and getting them to you. If you're a self-insured group, you are responsible for producing these and for getting them to your employees. Now, they're 8 or 9 pages long, so it's a lot of paper here, and you have to produce one for each particular plan that you're offering your employees. Now, this does apply to all employers with a group plan, so regardless of the size plan you're on, if you're offering a group plan, you need to make sure you distribute these summaries of benefits and coverage. Now, going on into how the program is implemented and when it gets started, it's for open enrollments that begin on the first day of open enrollment, rather September 23rd, 2012 and beyond, and it's for not only the first day of open enrollment, but also for special enrollments like the 60 days, for new employees that come on after they've joined your plan. Now, in addition to that, there's a 60-day notice required for employers that want to change plans after their original anniversary date. So we have a lot of small employers that say, look, we're going to go ahead and renew for now, but then later down the road, we're going to move to a higher deductible. Well, they can do that, but in order to do so, you've got to give your employees at least a 60-day notice. Now, how do you distribute these forms? That's a big question that needs to be answered here, and we're going to take an attempt at that. First is that you can do it by paper. But if you think about it, 8 or 9 pages per form, and if you have 3 or 4 or 5 or 6 plans, like a lot of employers do, That's an awful lot of paper to print and distribute. So a lot of employers are going to try to distribute this through an electronic means, and you can do that, but be careful because there are some serious ERISA regulations around the distribution of this type of material electronically. You want to make sure that you're in compliance with all that.
So it's something, just to kind of summarize, Todd, it's going to be a requirement that your carrier, for most folks, will be providing you with this information, but it's going to be the employer's responsibility to distribute it out there to all their employees.
That's right. That's right.
So be on the lookout for that.
And then come March 1st, 2013, we have more regulations.
That's exactly right. I suspect if we were to poll our audience and ask them how many folks are aware of this requirement that they probably have on them March the 1st, my suspicion is probably 90% of them don't know that come March the 1st of 2013, if you're an employer who's currently covered by the Fair Labor Standards Act, which is most everybody, then you've got a notice that you've got to distribute to all your employees about these state health exchanges. Now, we'll talk about the exchanges here in a little bit, but on March 1st, 2013, you must distribute this material out to your employees. And for every new employee, every new hire after March 1st of 2013 has to get this notice about the exchanges, the availability of the exchanges, what the exchange is, and also notice about the impact it may have on your employer plan with those exchanges. So that's coming. This is, again, like our continuing theme here. There are regulations yet to be written about this. So we don't know exactly what this is going to look like, but all we know is currently the law says March 1st of 2013 we have to do it. So stay tuned. And of course, if you're a Landrum client, that's the kind of thing that we're doing for you. We're staying up with the regulations, knowing what it takes to be in compliance, and we'll be getting that information out to you so you can get out to your employees. Another change coming in 2013 is flexible spending accounts, Amy. I know there's a change there.
There's a change there, and it's actually something that people should be considering right now. Beginning January 1st of 2013, the maximum amount that a person can elect for their flexible spending account is only $2,500. That's substantially lower than it is this year. And because those plans are being written right now and people are making their elections, they need to know that now, because you don't want employees having higher unreimbursed medical expenses that they're not anticipating simply because they made an election that they weren't allowed to make. So $2,500 per person is the amount, or per enrollee is the maximum amount for 2013.
Another sort of continuing theme about all this is taxes. There's going to be some taxes on high earners.
There are some new
taxes. They're going to kick in there, so let's talk about those first. We'll be talking about several taxes in the next few minutes, but the first one on high earners.
I get to do the first one. I get to kick it off. If you are an individual and your adjusted gross annual income exceeds $200,000, or if you jointly file and your adjusted gross annual income exceeds $250,000, there will be some extra taxes on you. For example, there will be a 0.9% hospital tax, Medicare hospital tax. And in addition to that, you'll have a 3.8% Medicare tax on certain unearned income, not your traditional W-2 wages, but unearned income.
Gotcha.
So potentially two types of taxes on those people who earn either $200,000 individually or who file jointly with a total of $250,000 or more. Okay.
Now, as I mentioned, if you're watching this webinar live, we are taking your questions. You're welcome to email questions to us at questions@landrumhr.com. We'll answer them if we have time during today's webinar. If we run out of time, then we'll be sending you a personal response to your questions. So send us questions at landrumhr.com. All right, let's move on to 2014 now and talk about the issues that impact us in 2014. Probably the first one, probably one of the most confusing ones, is about the employer mandate. So Todd, why don't you talk to us about this 2014 requirement?
That's right, Ted. And not only has it confused a lot of employers, but it's among their biggest concern as well to make sure that they stay in compliance with this, and they want to know how it's going to impact them. But first, before we get into that, we need to define who is it actually going to apply to here. And it really it's only going to apply to employers that have 50 or more full-time equivalents. Notice we didn't say full-time employees because there's a difference. If you're an employer that say has 40 employees and you sit back and say, well, I don't think this is really going to apply to me. Well, not so fast, my friend. It very well may. And that may be because you have enough part-time hours going on that you could be above the line and not really realize it. Now, when we look at how to calculate this, it really is quite simple. And here's a thumbnail sketch of it. what you do is simply just take the number of employees you have that already work over 30 hours and add to that the number of monthly part-time hours you have divided by 120. And that will give you the number of full-time equivalents. Now, there's also additional rules on how to deal with seasonal employees, and you want to be careful about that as well.
And again, a continuing theme here, these regulations aren't final yet. This is a 2014 provision, so there may be some change in that calculation. So we just want to make sure everybody realizes that this is the information we have at the moment. This is the way it appears to be. There is some consideration about changing the hours for the part-timers, and so stay tuned for the ever-changing look at these regulations.
That's right. That's right.
Now also another point about, well, before we get there, let's go and talk about the issues, about the ways you can be penalized, Todd, with the employer mandate.
Right. Well, I think a lot of employers want to know what they have to do to avoid being fined, and there's really 3 tests to pass. And this is for only those employers that are above that 50 FTE line. So just keep that in mind. If you're below 50 full-time equivalents, this doesn't apply to you. But if it does, and you want to avoid fines, the first thing you've got to do now is decide whether you're going to pay or whether you're going to play, because this is it now. 2014 is not far away. You're going to have to make some decisions. So if you're going to offer coverage or not, that's the first question that you have to answer for yourself. Second thing, though, is that if you do offer coverage, you need to be careful as well, because the coverage needs to be what they call affordable. In other words, the employee's portion can be no more than 9.5% of their household income for the coverage to be deemed affordable. So you have to watch payroll deductions with it as well. And in addition to that, the coverage must be sufficient. In other words, it has to meet certain governmental standards in terms of what the benefit levels are and what the benefits may cover.
And I guess an important point about this is to really think beyond this, really the pay or play is what you hear a lot of talk about in the press, but it really is a fundamental HR question in our view. If you're already offering coverage, if you already have a benefit plan in place, you're probably doing that to be competitive with against the other employers out there. So if you're already offering coverage, you most likely are going to continue to offer coverage because you need to attract and keep the best employees that you want. So if you look at the experience in Massachusetts, employer-sponsored plans actually, I think, went up in participation after the healthcare reform went into effect there. So if you're offering coverage because you want to attract and keep the best employees, you likely will continue to do that in the future. That's
right. And most all surveys show an overwhelming majority of employers that are offering coverage today plan to continue to do so.
Right. Absolutely. Well, there's also there's an individual mandate. We talked about the employer mandate. There's also an individual mandate that requires all of us, compels all of us to get coverage. So, Amy, why don't you talk about the individual mandate?
That's exactly right, and it's exactly what it sounds like. What it says is that each person has a responsibility to get health insurance in some way, shape, or form, whatever they choose. In 2014, the fine that will be attached to this if they don't comply will be $95 or 1% of their adjusted gross annual income. In 2015, it goes up a little bit to about $300, $325 or 2%, and then it goes up the following year to $695 or 2.5%. But it's on a scale that goes up every single year, and it's designed to incentivize people to go ahead and comply with the law.
Gotcha. Todd, also out there's going to be some changes in the insurance market itself. The first one we're going to talk about is the guaranteed issue.
That's right. Effective January 1st, 2014, regardless of your medical history, regardless of your medical condition, if you want coverage, you'll be able to get it without any questions asked.
Mm-hmm. So that's a significant change.
A majorly change, especially, Ted, in the individual market where today people can be precluded from coverage for those conditions. But not so much in the group market, but easily so for the individual. It's going to remarkably change things.
Yeah. Well, let's talk about the pre-existing conditions, Amy. That's another, Todd touched on that, so another change in what we're going to see in the marketplace.
Todd's exactly right. Prior to PPACA being instituted, an insurance company could deny or limit coverage based on a pre-existing condition. And in 2010, one of the first things the law did was said they couldn't do it for children under 19. So a child under 19 with a pre-existing condition couldn't be denied or have coverage limited. In 2014, that will roll out to all enrollees.
Okay. Well, again, I hate to keep coming back to this recurring theme, but we have a recurring theme about these changes in regulations. We're anticipating a a whole host of new regulations that are going to come upon us as we go forward. Let's talk about some proposed regulations that are currently out there and in some cases being put out for comments by the regulators. But let's talk about that first, Todd, then the proposed regulations about the minimum coverage, minimum values.
That's right. Yeah, what we're saying is essential benefits, minimum values. What this is really, Ted, is the government's description of what a plan must look like, both in terms of the level of coverage and the items that must be covered underneath each plan.
Mm-hmm. In addition to that, there's some other market reforms that are going to be coming into place as it relates to the insurance market itself.
Yeah, and they're quite remarkable when you look first here at the new rating rules. You know, this has really gone relatively unnoticed by the media. It really wasn't spoken a lot about during the campaign, and I don't think a lot of people really know about it, but it's going to have a major influence on the way that insurance companies go about rating their individual customers and small group customers. No longer, effective January 2014, will an insurer be able to use gender, medical history, medical conditions, even industry as a rating factor for individuals or small group. They can use still age, where the folks live, the plan design that they choose, whether or not they use tobacco, the size of the family. They can use those things. But what it's going to do, too, is somewhat compress the rate bands that are in place today. See, today there's a pretty broad range between the most risky and the least risky in what the insurance companies use to rate groups and individuals. And that's going to collapse come January of 14. And it's going to go from, say, a 1 to 10 to about a 1 to 3 ratio. And what that means, Ted, is good news for some, not so much for others. Good news for people like you and me that might be getting a little bit of a break. Bad news for you, Amy. You're on the younger end of the age spectrum, so you're going to be drug up by people like Ted and me.
I appreciate that, Amy.
Thank you very much.
You're welcome.
You're welcome.
Taking care of that for us.
Anything I can do.
Well, I appreciate that. You know, there's been a lot of focus in the recent years in the insurance market about wellness programs, about trying to incentivize employees about wellness. I think there's a change in the way that employers can deal with wellness programs in the workplace.
Well, again, this is something that's evolving that we're going to have to watch, but the government recognizes that a healthier workforce is a less costly workforce, and a healthier population is a less costly population in general. So there are ways to incentivize employees to participate in wellness programs that are becoming a little more generous than they were in the past.
Mm-hmm. So we can expect to see that out there in 2014. Mm-hmm. Additionally, Todd, we've got some more regulations that are coming out that are going to be expected for the 2014 year. This one relates to auto enrollment. So talk about some of these additional regulations we're expecting.
Sure. Yeah. Well, we've got a couple of them here. One of them, the first one there is auto enrollment, and that's exactly how it sounds. Is that if you have over 200 employees, your employees will be joining the plan when they come to work for you, regardless, and it's going to be up to them to opt out of the plan. So. Most employers in this neighborhood are not over 200 lives, so it's not going to impact them. But for those that are, you're going to need to be getting things in order. And when the regulations are released, be ready to go.
Right. Also, Todd, non-discrimination testing, a very complicated subject, one that I think even the regulators, it sounds like, don't really want to tackle at the moment. And thankfully, they've given us kind of a break to deal with the non-discrimination issue, but talk about that testing.
Right. We don't want to tackle it either. And of all these rules, we're really quite thankful that this one has been put on the back burner for some time. But we do hear from the insiders that it's not too far around the corner from issues being released, or regulations rather being released. And it's going to only apply to non-grandfathered plans. So if you're grandfathered, this will not apply to you. But at a minimum, what it's going to say is that employers will not be able to discriminate against lower compensated employees in the way of plan design and plan offering. We don't know yet if this is going to also include provisions around contribution differentials and things like that. We're going to have to wait and see. Our greatest hope at this point is that it won't take a consulting actuary to conclude whether or not your plan is discriminatory.
Right.
That's truly the way it is today. This was modeled after a thing called Section 105H, which applies to large self-insured firms. And they do have to employ consulting actuaries to determine if their plan is discriminatory.
Yep.
So hopefully it won't take that moving forward.
Yep. Another big issue that's looming out there in 2014 are the exchanges. I know there's been a lot of conversation in the press and a lot of confusion, I think, of folks about the exchanges. What we do know, at least today, what we know is come January 1st of 2014, we'll have an exchange. What that exchange will look like on January 1st of 2014, we don't know. You have basically three options. The state does. The state can choose to run the exchange themselves. They can choose to partner with another state and implement a multi-state exchange, or they can simply say they're not going to do anything and let the federal government do that. It's a mixed bag out there across the country, with some states who are already well along the way of establishing their exchange. Others are beginning to make some movement in that direction, while others have already said no, they're not going to offer an exchange. So we're waiting to see how that shakes out, particularly in Florida. We don't know exactly what that's going to look like. What we can expect, however, is a relatively high level of complexity. That this is going to be buying health insurance is already a complex task. To go out there and look at using an online marketplace as a place to purchase your coverage may be problematic for some. What we've seen, again, going back to the Massachusetts model, that the exchanges have been used primarily for individuals who are receiving some sort of government subsidy. That's where the bulk of the business is on the exchanges there. If you're an employer who is offering coverage now, you more than likely will continue to offer coverage, and you'll probably continue to acquire it in the way that you always have. But that's, as I said, yet to be seen exactly how that's going to come out. Let's move on and talk about what we see as some outcomes and solutions. We've presented a lot of information here today with a lot of information, but we do think we have some solutions for folks that we can present to them. And let's move on and continue the conversation about exchanges, Todd. We've got the effectiveness of those exchanges kind of up in the air, aren't they?
They really are, Ted, and you alluded to that earlier. But what folks have got to realize is that this is not a particularly attractive risk model for the insurance companies. When you think about it, historically, the insurance companies have been able to define a population, observe the risk, and develop a rate. And now all that's going to change. So it's really going to be up in the air for a while as to how aggressive and how committed the insurance companies will be as it pertains to these exchanges. So.
Right, okay. Amy, we've talked about taxes on all kinds of folks, but there's some additional ones we haven't talked about yet. Why don't you talk about the impact on insurance companies and other folks?
Well, in addition to the individual taxes and the employer taxes, there's going to be some third-party taxes as well. For companies such as those who create medical equipment or insurance carriers, there are going to be additional monies levied against them, and that's probably going to increase their operating cost, which might ultimately get passed on to the consumer. I think that's a reasonable assumption.
Okay. So more taxes, more fees, more things to be concerned about.
I know.
Yeah. All good.
Yeah, all good. Todd, there's also going to be some changes regarding benefit requirements, particularly on the value that plans are supposed to look at. Talk to us about that.
Exactly, yeah. Most plans today will not match up with the requirements because there will be new mandated benefits. For example, for non-grandfathered plans, you will have to cover clinical trials, and those can be very expensive, but it might open the door for cures that people might not otherwise would have been able to experience. But most of the plans out there today are not in force, or that are in force rather are not in compliance, but some are more so than others. So we're going to have to work that through on a client-by-client basis as we move ahead. I guess what is really concerning for us mostly right now for individuals and small groups are the rating rules that are out there. And we do expect a significantly adverse impact for most importantly the individuals, and then to another extent the small groups. But those that have the younger healthy small groups or the younger healthier individuals are going to be pulled up because of this.
Mm-hmm. Amy, we've talked a little bit about pre-existing conditions, and I'll talk to us one last time about that.
Well, just beginning in 2014, no enrollee can be denied or have their coverage limited due to a pre-existing condition. That's currently the state of affairs for children under 19 for dependents, but in 2014 it rolls out for all enrollees.
Mm-hmm. Todd, individual and small group rates. This is not going to be a very pleasant conversation, but talk to us about what the expectation is for the impact on just these individuals in the small group market.
Seems like we get to deliver news like this all the time.
It sure does. It sure does.
But really, when you combine all these things, the new taxes on insurance companies and the manufacturers of healthcare, such as pharmaceuticals and medical equipment, the new benefit requirements, the rating rules, no pre-existing, guaranteed issue. You pull all those things together, there's only one way for cost to go, and that's north. Recently, I had a conversation with one of the major insurance companies, and they're predicting that in 2014, their individual market rates will go up between 100 and 200%. They're predicting that in 2014 that their small group rates are going to go up 25 to 50%. Those on the higher end of the spectrum will be those that were younger, healthier in the past. So that's what we're going to see, I think. We don't know if these numbers are actually going to be the ones that play out. But what we do know is that an organization and a program like you have at Landrum may be a good solution for a lot of employers, Ted.
Yeah, I was going to say, I think we've talked a lot about some unpleasant topics, I guess, for lack of a better word, as we've gone through the day-to-day talking about the taxes and the mandates and requirements on folks. We do think we have some solutions at Landrum that can help employers. First off, if you look at our group health plan, it does operate in some ways like a private exchange, where we have a number of benefit plan designs out there that individuals can choose from. In addition to that, of course, you've got the individual and personal attention that we can give you at Landrum. And I think probably from an employer's perspective is the fact that we're there to keep track of these rules and regulations for them, to give them the kind of guidance and advice that they need. And I think give them the guidance in a kind of a holistic kind of approach, that they need to be looking at it from what's best for their company, what's best for their business, what's best for their employees, what's going to, as I said earlier, allow them to attract and retain the kinds of employees that they want to do. And as the landscape changes over time, it may mean that there are some other changes in their benefit design that needs to take place, and that's what we're there for, is to assist them through that. In addition, we have a new ebook. It's out this week. The Busy Business Owner's Guide to Healthcare Reform. I just want to point out that is not a Landrum client on the cover. That's a non-Landrum client on the cover who just can't figure this out. But if you're with Landrum, you're relaxed and you're focused on growing your own business, because you know we're taking care of you there on the back end. We've got some questions that have come into us, as I mentioned earlier. You're welcome to email us questions@landrumhr.com, and we'll respond to them in our remaining time here. And then if there's any that come in afterwards, we'll answer them individually. The first question, this person wants all their employees on their insurance plan. The question is, if an employee opts to go with a co-op, is the word that's used here. I suspect they probably mean an exchange. Are we penalized? Can we make it mandatory for new employees to sign up or show proof of insurance? Well, first off, this really kind of goes back to the employer mandate question. Right. If this individual has 50 or less full-time equivalent employees, then they're not bound to offer coverage. So there is no penalty if they choose not to offer coverage. Regarding the compelling the person to be on the insurance plan, Amy, I don't know that's probably an individual matter we want to sit down with that individual and talk to them about. Yes. Probably short of some kind of employment contract, I doubt that you could compel them, but that's really a legal advice. We'd want to sit down with that individual and discuss it with them. I
agree, yes.
But the key point, I think, is to look at that 50 employer question, 50 full-time equivalent question, and see, does this even apply to you? Are you even compelled to offer that coverage or not? And then that'll, I think, guide the rest of that answer.
That's right.
The second question is, being a Landrum client, how does the law look at me? Will I be considered a large or small employer? Well, fortunately, there is a provision as the law was being discussed, there was a provision in there that basically for many of these issues, it's called a look-through provision. Mm-hmm. You look through us, through Landrum, at the individual condition of that client. So if you were a small employer, let's take the employer mandate as an example of that. If you were considered if you were at less than 50 full-time equivalents, you're considered that's in that particular part of the law a small employer, then that's the same whether you're with Landrum or not. In many of the issues that go through the law, it looks through Landrum to the individual client for determination about the impact the law has on them. That's true of many of the provisions of the law. The third question, most of our employees are under 25 and earn $10 an hour. Is there a certain level of coverage we must offer? Is there a certain percentage of employees that must participate, and what percentage of premium must we pay? Well, again, this goes back to the 50 question or not, 50 full-time equivalents or not. If this particular person had less than 50 full-time equivalents, then they would not be required to offer coverage, would not have a requirement to pay any premium for that matter. Mm-hmm. If they're a large if they're over 50 full-time equivalents, then we're back to the issues that Todd talked about earlier. Right. Are they offering coverage at all? Is the coverage affordable?
With this younger bunch, that'd be the one to really look for, is the affordability piece.
Exactly right, with the $10 an hour factor as well.
Right.
But again, that's going to apply to whether the employer mandate, again, 50 full-time equivalents is the cutoff, and so that's really the factor to help guide these questions. All right, our next question. Getting it up here on the teleprompter. What are the implications for an employer who only has 4 to 7 employees and already offers insurance coverage? Again, they clearly are below the 50 full-time equivalent number in this case. They're free to continue to do exactly what they're doing now.
You just want to watch for the summaries of benefit coverage and make sure you get your notices out.
That's exactly right. There are some things that apply, as we've said, across the board to nearly every employer. But on the issue of offering coverage and your contribution to coverage, that doesn't change. But again, as Todd pointed out, there are things you do have to be concerned about, and as a Landrum employee, we'll take care of that. The maximum flexible spending account contribution is $2,500 per enrollee. How much is the maximum per family? What if my husband wants to contribute to his own flexible spending account through his employer? We may need to get back to you about this one. I think it's. I'm not.
I think they can do both.
I think that. Well, I'm almost positive they can do both. But let us, and we have your email address to the questioner there. We'll respond to that. We'll also post the answer on our blog. That's landrumhrblog.com, where we'll have an answer to that question about the flexible spending accounts. Next question.
This one's going to require some math. We might have to pull out a calculator.
All right. We have 5 full-time equivalents employees. 2 officers work. 5 full-time employees working 40 hours. 2 officers working 40 hours, and 2 part-timers working 15 hours. How will this impact us? Do individual mandates of 2014 affect our company employees? Well, again, they're below the 50 full-time equivalents in this particular issue, so they would not be impacted by the employer mandate. The individual mandate, however, would apply to virtually every individual in the country. There are some narrow exceptions for the individual mandate, but it does pretty much cover every individual. So they would be required to have coverage. If you're already offering coverage to your employees, then they're going to, if they take advantage of that coverage, then they're going to comply with the individual mandate. Next question. What if our small group plan doesn't grandfather?
I think the thing there is to make sure first that you're looking out for the non-discrimination testing. But in terms of benefits and such, most insurance companies' small group plans are all healthcare reform compliant, and in fact, some insurance companies in their small group market don't even offer grandfathered compliant or grandfathered plans rather. So they're automatically, for the most part, compliant in terms of benefits. They just need to watch out for this non-discrimination testing coming around. Yeah, and it really, Todd, I don't know what your experience has been, but I'm assuming the vast majority of plans out there are non-grandfathered plans now. That's pretty much what most employers either didn't have a choice or just chose simply not to. That's right. Yeah, most of them want to stay in the driver's seat with respect to benefit changes, employer contribution changes. So that's right, Ted. Yeah, most all of them are not grandfathered right now. Yeah, really, the whole, in order to keep your grandfather status, you pretty much had to only add folks and drop folks from coverage. That's about it. You really couldn't make any other substantial changes to your plan. Minor benefit changes, minor changes to employer contribution. Right. So, that alone caused most folks to lose their grandfather status. The next question is, what are the fines, and is it cheaper to pay or play? Well, again, we can actually help you with this calculation. There are 2 different fines. There's a fine for not offering coverage. Then there's also a fine for if you don't meet the affordability or adequacy test. It's a little complicated. We probably can't go over it here with you, but basically you have to look at the way you calculate the fines are different depending on what you violated. If you don't offer coverage at all, there's one method to calculate the fine and one fine structure. If you decide that you're offering a plan but it's not deemed to be adequate or affordable, it's a different level of calculation. So that's probably, we actually have developed a calculator that we can sit down and go through that calculation for you. And in addition to that, the rules have not been finalized about how this penalty is going. Exactly right. The rules haven't been finalized about that calculation. So even if what we look at today
Take, for example, the affordability question. The law talks about household income. There's been some IRS points out there for discussion only. It hasn't been adopted by the IRS that relates to W-2 wages. So what we show you today may or may not be what the final rule is like by the time we get to 2014. So, and again, I would encourage you not to focus on the pay or play question. Focus on the role that benefits plays in your employer status. That's really what the issue is. If you need to offer coverage because you can't find the right kinds of folks, or you feel like you need it to keep the kind of folks you want to keep as employees, then the pay or play thing really probably isn't going to really be a factor for you.
That's right.
So I just really would encourage you don't focus on that. How will HSAs be affected, Todd?
Well, in one
Health
respect,
savings accounts. I'm sorry.
Health savings accounts. The penalty a couple of years back now was changed for a non-qualified withdrawal from 10% to 20%. But outside of that, there's really nothing that's been changed. In fact, the administration has allowed for an increase in the amount that can be put away in HSAs again for 2013. So it looks like they're continuing to view them as a viable alternative for a lot of folks.
I think there may be some issues about plan value and the calculation of the actuarial value that'll come in down the road as we determine the adequacy business.
That's right, but the HSA, if it's employer contribution, can be treated as part of that benefit.
Exactly
tax.
right. Yeah, exactly right. If a client owns more than one business, how is that handled as a common ownership? Well, that's exactly right. For most aspects of the law, it is looked at as common ownership. The rules that go into effect now, they're already in place in other parts of the law, not the healthcare law, related to common ownership. That's really the standard. And if you've got multiple businesses, I think part of the concern was that a concern that employers might try to break themselves apart and go into form different companies to try to avoid the employer mandate. And so there is a common ownership provision to the law, and so that's what's going to guide you today.
Yeah, you read the language, and it looks like they're really going to be on the lookout for that. So just be careful.
Yeah, exactly. What's the formula for calculating FTEs again? Well, it's pretty simple. I mean, you first start with you take the employees that you currently have that work average more than 30 hours per week. So that's, in fact, thank you for bringing up the slide. You look at those, so that's one number, those that work more than 30 hours a week. Then you simply take you take a month and take all your part-time hours and divide that number of hours by 120, and that gets you basically a full-time equivalent. 120 is just simply taking 4 weeks in a month times 30 hours a week, gets you 120. So you take your hours, divide by 120, add that to the number of employees that work more than 30, and that gets you your full-time equivalents. And that's where that 50, that's the key measure for the employer mandate is 50. If you have 50 or more full-time equivalents, then you're required the employer mandate applies to you. If you have less than that, it doesn't.
Unless we use 130 ultimately.
Well, I was going to say, isn't that something to change very soon?
Well, it may be. It may be. Again, I think there's some IRS rules out for comment now that change that 120 to 130 since most months have more than 4 weeks in them. Right. So 130 is what you may see. And again, that's a January 1st of 2014 provision, so we've got time for these final regulations to be written. But yes, that's one of those things that's the ever-moving target. How is COBRA affected?
I haven't seen anything yet.
Yeah, I haven't either. I don't think there's any impact on COBRA. Right. It is, as Amy mentioned earlier, it is used to calculate the value. The COBRA value, I think, is typically what's used to calculate the value you're going to place on the W-2s for the value of the benefits that you're offering. But
employees that leave their employment will have another option, and that's to go to the individual market and purchase guaranteed issue coverage.
That's true.
So they'll be able to compare prices and see what works best for them.
That's very true.
Yeah.
There's a question about which organization qualifies for the faith-based exemption. Now, I'm not sure that I know the answer to that question. We'll have to email you back the answer to that question, as well as I mentioned, if you'd go to our blog, the LandrumHRblog.com, these answers that we don't get to today, we'll post the answer on the blog. But there are some exemptions. There's exemptions both on the individual mandate. There's also exemptions, I think, on the employer mandate, but I'm not sure.
We do know it's not going to be your mainstream religious organizations like Baptist, Catholic,
Right.
that kind of thing.
Right.
The individual mandate exemptions are, for example, people who are currently covered as a dependent on somebody else's tax returns, somebody who is incarcerated, certain members of recognized Indian tribes.
Right.
There's a list of enumerated exemptions, but largely it's intended to cover the entire population.
Right. And I believe for many of them, you have to go to the exchange and be certified that that exemption
You have to
applies
qualify
to you.
for
You
it,
have to
clearly,
qualify
yes.
for it, right? And since we don't even know who's going to run the exchange, we can't even be sure yet what rule they're going to use to determine that. So again, we'll try to see if we can find an answer to that and get back to you with that. Address the affordability of coverage a little deeper. Again, that's one of those areas where we don't know. The law, as I recall, the law specifically talks about 9.5% of household income as the test of affordability.
Maybe with the safe harbor that they're considering, it may be 9.5% of W-2 wages, which would be easier for the employer to track and understand. But at the same time, when you think about it, it has the effect of lowering the bar.
That's right.
Making the affordability test harder for the employer to meet in most likelihood.
Right. Again, as the regulators are looking at this issue, they realize the difficulty of an employer knowing household income. And so that's where this proposal is out there to change it to W-2 income, which, as Todd mentioned, really has two impacts. One, it makes it easier for the employer to calculate, is my plan affordable? Does it meet the affordability test? Because I know what the W-2 wages are. But then secondly, because you're looking at W-2 wages and not household income, it does lower the bar and may have more people qualify for subsidies that are out there, or perhaps deem plans to be unaffordable. So, but that's basically what we know. What the law says is 9.5% of household income. The next question is about, we mentioned earlier, the employer mandate penalties, and about the calculation of those penalties. I think unfortunately, we don't have a slide for this. I think what we'll do is answer this question on the blog, because there's a penalty for not offering coverage, there's a penalty for offering unaffordable coverage, and a penalty for offering inadequate coverage. They're calculated, the two major groups calculated differently. And then you can exclude a certain number of employees. It has to do with the number of employees who take subsidies. As I said, it's a bit more that I think that we can explain here, but we'll show the full calculation, again, based on what we know at the moment, on the blog. So that's landrumhrblog.com, where we'll have the answer to that question. We'll email this individual with the answer and also post it on the blog. It's also covered in the book, by the way, if you want to purchase the ebook on Amazon and then the paperback book soon. What is an exchange? The exchange, if you think about it, is really an online marketplace, for lack of a better...
Virtual marketplace.
A virtual marketplace. It's a place where consumers will go and be able to look at a number of different insurance carriers. They'll be sort of, in all likelihood, sort of segmented by types of plans, at least by the coverage,
plans,
right? There's gold, silver, bronze, and platinum plans, and they'll be similar probably in makeup. Yeah, the Young Invincibles, right? And the individual will be able to go in there and make some level of comparison, and then be able to purchase them there. So think of them as a virtual marketplace. What we don't know is what's going to be offered out there. How easy are these plans? I mean, is it going to be to navigate and understand these plans? I mean, these exchanges, since each individual state there could be 50 different ones of them, although I suspect be a fair number of federally run exchanges. It's what it's going to look like and how easy it's going to be to navigate a whole different question. And as I mentioned earlier, Massachusetts is primarily those individuals receiving a subsidy is primarily who takes advantage of the Massachusetts plan. Some small group, but primarily that. Todd, you're going to...
Well, we experienced this in Florida in the early mid-'90s with the Community Health Purchasing Alliances, and the idea was essentially similar. There's a few different twists with the exchanges, especially built around the subsidies, which is going to force a lot of folks into it. But in Florida, we did have those, and it didn't work out very well because of the risk model that we talked about earlier and how the insurance companies viewed it.
Right. Yeah, exactly. The next question, will employees be required to disclose their household income to their employers? That's the issue we talked about earlier with the problem with the employer mandate. I believe that's the way the law is written, is it is household income. Obviously, this is problematic. I'm sure most employers don't want to know the household income of their employees.
And vice versa.
Mm-hmm. Right. Employees don't want to disclose that information. I think that's why I believe it was the IRS proposed the W-2 wage safe harbor method, so that would be all the employer would have to do to answer this affordability test question. So again, that's one of those, we don't know what their final regulation is going to look like. I don't know, Todd, I think I'd be surprised, or Amy, that ends up being in the final rules.
I think the W-2 is a cleaner way to go. It's black and white. There's no questions about different incomes. If you have many people contributing to the income of a household, how many W-2s do you have to submit? That would be really, really difficult for employees as well as employers. Right. It would be very cumbersome.
It would be. Well, Todd has a fan. You got your own personal question here, Todd. The question reads, Todd, does the ACA, the Affordable Care Act, apply to Medigap supplement coverage?
Not in the context of how it affects employers. Yeah, and I'm not really familiar with where it's going to carry us beyond that. I'll look into it and get back with the group, but there's nothing really there for employers to be concerned about.
Okay, very good. Well, it looks like that's the last of our questions. Let me thank Todd and Amy. I want to thank you both for being with us today and helping our folks understand this very complicated issue. We would invite you to visit our blog, as I mentioned, landrumhrblog.com. If you have additional questions, you're welcome to send those to us at questions@landrumhr.com. I would also remind you about the ebook. As I said, it'll be out this week on the Kindle, and it'll be available in paperback soon through Amazon and local booksellers as well. And again, visit our blog for more information as we keep you up with this very important issue. We thank you for tuning in.
Thank you.
Thank you.